Welcome, everyone. We are here with Barbara Johnson. She will be speaking at this year's Changing Currents in Employment Law at the DC Bar on October 29th of 2019. Barbara, welcome.
Thank you.
So I was interested in looking at your bio, just how varied your experience has been, and you've just gone from kind of big law to opening up a much smaller shop. Give us a sense of, behind that decision. What was going on?
As much as I had enjoyed my time at Big Law, had amazing experiences there, I really missed the day-to-day advice work and being able to talk to clients, be in the trenches, dealing with them. And the reality is that the economic model for Big Law doesn't really lend itself to that very well. So now I'm counsel with a woman in minority-owned firm, and there's 7 of us, which has worked out really well.
So my guess is you can be a little more nimble.
Yes.
Tell us a little bit about counseling employers, and especially on your topic, which is bring your own device to work. What are some of maybe the things that an employer should think about before they institute a policy like this?
Well, first of all, they need to have a policy, and because many employers just kind of let this happen, employees start using their own laptops, using their own cell phones and iPads or whatever, and they don't really think about it. And then the challenge is that the employee has access to all of the employer's confidential information. And what happens when that employee leaves? What system does the employer have in place to get that information back?
So this isn't something that the employer should just allow through happenstance. It's something where they need to actually think about what they want to do in advance.
Yes, including things as simple as having employees use personal email addresses, right? As opposed to the information being housed on the company's server. So there are lots of aspects of this, as well as the employee thinking, this is my device. So what do you mean you're going to wipe out all of this information when I leave? Because my kids' pictures are on there. What's up with that? So just thinking through and educating the employee about what to expect as well.
So for an employer thinking about putting in such a policy, maybe a few things that you give advice you give to clients right at the outset as they're thinking about such a policy.
Mainly to be proactive, and mainly to ensure that the employee understands that the information that is housed on their personal device is the company's information. And putting in place, I advise, the technology that will allow you to erase that company information from the personal device if and when the employee leaves your employment.
So give us a little sense of maybe about the panel and some of the things you're going to be talking about at Changing Currents 2019, Bring Your Own Device Policy panel. Give us a sense, if I'm in the audience, what am I going to see?
What you're going to hear about, first of all, is some of the best practices as far as if you do decide, first of all, the pros and cons of allowing employees to use their personal devices. And then if you decide that you are going to implement a Bring Your Own Device to Work policy, some of the issues that you need to look at, some of the Fair Labor Standards Act issues as far as employees working off the clock, where you have hourly employees that are answering the emails and working away. Yes, so there are lots of issues to be thinking about, and those are some of the things you'll hear about.
So that must be a counselor's nightmare, right? Having someone an hourly employee responding to emails off time. What do you tell an employer? Because they want that employee to be responding. But what do they do under those circumstances with the Fair Labor Standards Act?
Well, you need to have some way of recording the time, unless it's de minimis. If it only is taking a couple of minutes, but if you know that an employee is doing more than just a de minimis amount of work, you really do need to have some way of capturing that time and managing those expectations, right? So you know that there are people who are going to email someone at 10 o'clock in the evening. Is that really what you want? So you need to be thinking through those after hours kinds of issues.
And my guess is the training associated with that, training managers and others in the policy, is that important?
Absolutely, yes. I mean, and it's that communication, because the fact that there's a policy in place really doesn't mean much if nobody's looked at it, if the employees are not aware of it.
So Barbara, tell us a little bit about your background before you became a lawyer. I saw that you were a chemist.
I was a chemist before I went to law school, and I was very fortunate because I met some people, they're both attorneys, and they convinced me that this was a good thing to do. And before you knew it, I was in law school and I was hooked.
Barbara, thank you.
You're welcome. Thank you.
We look forward to seeing all of you at Changing Currents in Employment Law this year on October 29th, 2019, beginning at 6 o'clock at the DC Bar.